Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, good morning. Our topic for today is on the right to self-organization. For our objectives, we have first, discuss the concept of the right to self-organization. Second is to explain the registration of labor organizations. And the third is to discuss unfair labor practices. Under Article 243 of the Code, it provides that labor organizations are those organizations that engage in an industry affecting commerce and includes any organization of any kind, any agency or employee representation committee, group or association or plans so engaged in which employees participate and which exist for the purpose. The concept of right to self-organization is being divided into two as provided in the code. One is the right to form, join, or assist labor organization, and the second is the right to engage in lawful concerted activities. So when do we have these concerted activities? Concerted activity exists when two or more employees take action for their mutual aid or protection regarding terms and conditions of employment. So as provided, workers shall have the right to engage in concerted activities for purposes of collective bargaining or for their mutual benefit and protection. So the right of legitimate labor organizations to strike and picket and of employers shall continue to be recognized and respected. So what is this union or employees organization? These are any labor or bona fide organization in which employees participate and that exist for the purpose, in whole or in part, of dealing with employers concerning grievances, labor disputes, wages, hours, terms, and other conditions of employment. So in short, these are any labor organization organized for collective bargaining or negotiation and for other purposes. Now, who are covered by employees organization? So all persons employed in commercial, industrial, and agricultural enterprises and in religious, charitable, medical, or educational institutions. It also includes ambulant, intermittent, or irregular employees and itinerant workers or traveling workers, self-employed, rural workers, and those without definite employment, and employees of government-owned and controlled corporations. Next question is where to file for registration. One is through the regional office where the applicant principally operates. Second is by the Labor Relations Division, and the requirements for applications includes one is independent labor unions. So this independent union refers to a labor organization operating at the enterprise level that acquired legal personality through independent registration under Article 234 of the Code and Rule 3, Section 2A of these rules. Second are federations and national unions. These are group of legitimate labor unions in a private establishment organized for collective bargaining or for dealing with employers concerning terms and conditions of employment for their member unions or for participating in the formulation of social and employment policies. And the third is workers' associations or association of workers organized for mutual aid and protection of its members or for any legitimate purpose other than collective bargaining. So these three are required for application for registration. Now class, in cases of cancellation of registration, who may file for cancellation. The, so any party in interest, except in actions involving violations of Article 241 or those pertaining to rights and conditions of membership. So this party in interest refers to any fiduciary, legal counsel, employee of an employer-sponsored benefit plan, or service provider to the plan. Next question is where to file for cancellation. So the regional director of Independent Labor Union or its chartered local and workers association, or the Bureau of Director for Federations, National Industry Unions, and Trade Union Centers. Now, what are the limitations for this registration? So, only legitimate or registered labor unions or workers' association can represent their members for purpose other than collective bargaining. And supervisory employees shall not be eligible to be with labor unions. So as managerial employees are not eligible to join or assist of any form to labor unions. When we say supervisory employees are those any individual, regardless of the job description or title, having authority in the interest of the employer to hire, to transfer, suspend, lay off, recall, promote, discharge, or assign, reward, or discipline other employees, or responsibility to direct them or to adjust their grievances. While managerial employees are those whose contract of employment requires or permits him or her to hire, to transfer, promote, suspend, lay off, dismiss, reward, discipline, or adjust the grievances of other employees, or to make direct recommendations on these matters to the employer. Another limitation is that alien employees with valid working permits, meaning national of a country which grants the same rights to Filipino workers. So this means any employee, whether employed for a definite period or not, shall, beginning on the first day of his or her service, be eligible for membership in any labor organization. Now let's talk about the grounds for cancellation. One is misrepresentation. Misrepresentation is a false statement of a material fact that made by one party which affects the other party's decision in agreeing to a contract. Second ground is failure to submit documents such as those necessary for the ratification or, let's say, financial statements. Third is acting as labor contractor or engaging in a caboo system. What is this caboo system? This refers to a caboo is a person or a group of persons or to a labor group which, under the guise of a labor organization, cooperative, or any entity, supplies workers to an employer with or without any monetary or other consideration, whether in the capacity of an agent of the employer or as an ostensible independent provider. So employees have the rights to legitimate labor organization, and by that they have the duty to bargain collectively. Article 253 provides the duty to bargain collectively when there exists a collective bargaining agreement. So this right to collective bargaining is the right of the individual employees in a workplace to come together and to choose a representative based on a majority vote who will then negotiate with their employer over terms and conditions of employment. So what is this collective bargaining? It is an agreement between a single employer or an association of employers on the other hand and a labor union on the other, which regulates the terms and conditions of employment. So what are the objectives of collective bargaining? One is to resolve differences over knotty issues. When we say knotty issues, these are complicated and difficult to solve problems between the employer and the employees. Second is to protect the interests of workers through collective action. So when do we have collective action? So collective action occurs when a number of people work together to achieve some common objective. However, it has long been recognized that individuals often fail to work together to achieve some group goal or common good. Third is to carry out negotiations voluntarily without interference from a third party. So in this case, no party is forced to participate in a negotiation. It should be voluntarily. It should be done voluntarily. Then fourth is to arrive at an amicable agreement through a process of give and take. Next is to arrive at an agreement on wages and other conditions of employment, and to have peaceful coexistence for the mutual benefits and progress. When we say peaceful coexistence, meaning they are working together in peace rather than in constant hostility. And last is to maintain employee-employer relation bilaterally. Now let's have the characteristics of collective bargaining. First is it is collective. It is a two-way group process where the employer's representative and employees' representatives sit together to negotiate in the terms of employment. Second is its strength. In here, both the parties are strong and equal in terms. Another characteristic is it is voluntary. Both parties come to the negotiation table voluntarily in order to go in particular negotiation. It is based on discussion, mutual trust, and understanding. Another is it is formal, because it is a formal process in which certain employment-related issues are to be regulated. And another, it is flexible. At the same time, a continuous process. And the purpose is for improvement. Method to improve the employer-employee relations. Another characteristic is it is true representation. Collective bargaining is between the representative of employees and management. So the management does not directly deal with the employees. It carries negotiations with the representative or executive of unions and association. The next is it is dynamic. Why? Because it goes on changing over a period and grows and expands the way of agreement, the way of implementation, and the way of discussion. Then we have the characteristic of being continuous. It continues and begins with agreement and the implementation of agreement and for further negotiation. And last is a bipartite process. It's because the employers and employer representatives negotiate directly face-to-face across the table. Now let's have some issues of collective bargaining. Okay, we have issues on wages and working conditions, on work norms, incentive payments, job security, changes in technology, work tools or techniques and practices, staff transfers and promotion, grievances, disciplinary matters, management rights, and insurance and benefits. Okay, now let's have the collective bargaining process. So it starts with the union claim, or the claims or issues to be settled. On the other hand, we have also the management proposal, or the formal document that contains information relating to the company's side of the issue. Then comes the negotiations. This is the strategic discussion that resolves the issue in a way that both parties find acceptable. So in the process of negotiation, all parties tries to avoid arguing but agree to reach some form of compromise. So these negotiations involve some give and take, which means one party will always come out on top of the negotiation. It's either on the side of the employee or that of the employer. So after the negotiation, the compromise might be referred first to a third party for review, particularly if it requires some legal aspects or some technical issues that needs expertise of a third party. Then after that, the collective agreement is approved. After that, the collective agreement will be signed by both parties. So here are the detailed steps in the collective bargaining. Start with the preparation. This involves the composition of the negotiation team, who will be part of the negotiation panel. Then the second is the discussion. This is where both parties decide the rules that will guide the negotiations. So it does not only the management that decide the rules. It should be both parties concerning the issue shall decide the rules. Then the next step is proposed. This involves the initial opening statements and the possible options that exist to resolve between them. Then the fourth one is to bargain. This comprises the time when what ifs and supposals are set forth and the drafting of agreements take place. And of course, the last is settlement. This is consisting of the effective joint implementation of the agreement through shared vision, strategic planning, and negotiated changes. Okay, class, now we have the unfair labor practices as provided from Article 247 to Article 249. Article 247 provides that the concept of an unfair labor practice and procedure for prosecution thereof, while Article 248 provides for unfair labor practices of employers, and Article 249 for unfair labor practices of labor organizations. So what is this unfair labor practices? This violates the constitutional right of workers and employees to self-organization. As such, it is inimical to the legitimate interest of both labor and management, including the right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect, disrupt industrial peace, and hinder the promotion of healthy and stable labor management relations. So thus, an employer may only be held liable for unfair labor practice if it can be shown that his acts affect in whatever manner the right of his employees to self-organize. So the same rule applies to labor organization. So how is it committed? An unfair labor practice may be committed either by the employer or the labor organization against the employee. Now, what are the unfair labor practices by employers? One is to interfere with, restrain, or coerce employees in the exercise of their right to self-organization. Two is to require as a condition of employment that a person or any employee shall not join a labor organization or shall withdraw from one to which he belongs. Third, to contract out or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their right to self-organization. Fourth, to initiate, dominate, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizers or supporters. Fifth, to discriminate in regard to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership to any labor organization. Six, to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony. 7. To violate the duty to bargain collectively. 8 is to pay negotiation or attorney's fees to the union or its offices or agents as part of the settlement of any issue in collective bargaining or any other dispute. And last is to violate a collective bargaining. Now we have the unfair labor practices by labor organizations. One is to restrain or coerce employees and the exercise of their rights to self-organization. However, a labor organization shall have the right to prescribe its own rules with respect to the acquisition or retention of membership. Second, to cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied, or to terminate an employee or any ground other than the usual terms and conditions under which membership or continuation of membership is made available to other members. Third, to violate the duty or refuse to bargain collectively with the employer, provided it is the representative of the employees. Fourth, to cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for fee for union negotiations. Fifth is to ask for or accept negotiation or attorney's fees from employers as part of the settlement of any issue in collective bargaining or any other dispute. And last, to violate a collective bargaining agreement. Now, the next question is, what evidence is required? So, in order to show that the employer committed unfair labor practices under the Labor Code, substantial evidence is required to support the claim. So class, when we say substantial evidence, it is more than a mere scintilla or shred of evidence. It means such relevant evidence as a reasonable mind might accept as adequate to support a conclusion, even if other minds equally reasonable might conceivably opine otherwise. Another question, class, is what is the extent of liability? So, an unfair labor practice is punishable with both civil and or criminal sanctions. So, for purposes of criminal liability, the ones liable are only the officers and agents of corporations, associations, or partnerships who have actually participated in, authorized, or ratified the unfair labor practices. Okay, so that would be all, class. And for your activity, interview at least 5 private employees regarding some unfair labor practices that they encounter. Ask them how these are resolved by the management. Make a conclusion out of their answers. So again, class, thank you for watching. See you in the next video.